food sweets, and then we share certain information about us to others, and our day starts like that. Why I'm trying to say this is that in our day-to-day daily lives, sharing information has became a mundane aspect, daily day-to-day aspect. If it becomes a daily mundane aspect, it becomes a day-to-day aspect. We are not that much concerned about what is happening about our data. My dear friends, we think that whatever the social networking sites we are using, they are free. But let me tell you one thing. I think the most of you know about this, as it was rightly said by a lot of people. If you are using something free, then you shouldn't consider that it is as a free. If you are using any kind of service free, it is like you are the product. So by just sharing our own data, we have become a product, and the companies, the big tech companies of the software, the social networking sites, they are milking a lot of billions of dollars out of our own personal data. We consider that what is the value of personal data? Personal data is not valuable for us, but it is valuable to others, because with our own personal data, that the companies can draw certain insights about us, and they can use such insights to advertise or to process for us, and they can gain a lot of profits. So in this juncture, whatever I have explained, the ultimate thing which protects us here is data protection and privacy. This data protection and privacy is not a new thing. It has started when human, or I say man, started to wear the clothes. First, he started to safeguard his own private parts, and that's how the parts became private. Here, the private parts means the body parts which cannot be disclosed, which cannot be disclosed in the sense that you will feel unease if without your consent, if certain other person sees that parts. It became private because the man has got an innate aspect that he should cover his body. First, he started to cover his body, and then he started to live in the caves, and from the caves, he started to live in the huts, where he felt that the outer world shouldn't have, or shouldn't be controlling him in his own home. That's how the law of privacy has been emerged, because what we felt that no one should have an express control over our own home. A famous landmark notion has been emerged with that, which means a man's home is one's castle. Can anyone try to explain or elaborate about this? A man's home, man includes women as well, but at that particular time, man includes man only. A man's home is his own castle. Can anyone who is joining in this class. Can anyone try to elaborate about this particular statement? In what reference it can be used? My man's home is his own castle. You can try to share anything. I'm trying to make it more discussion oriented. What does it mean by a man's home is his own castle? And even the Supreme Court in one particular case has used this notion. Can anyone try to answer? A man's home is his own castle. So have you heard about Farak Singh case? Whereas the police are repeatedly intervening the a person against whom the rowdy sheet has been given. The police are making domiciliary visits in the odd hours during the midnight times. Whereas in this particular correction case itself, the court has said that a man should be let alone in his own home, and he is not supposed to be disturbed. So law's ambit is there a lot, but it cannot enter into a person's home. What a person is doing with with, with others in the home, if it is consensual, then law shouldn't interfere. That's the major basic aspect which is emerged. And you know that that is the from that basic aspect only they have started. The courts have started to recognize certain other aspects as well, like decriminalization of homosexuality. So it says that if it is happening at a private space, we shouldn't. The law should not make that as a crime. So after that, this notion of privacy has extended to the person's communications when the man started to write letters. So earlier there used to be certain laws which specified that if you write a letter and you close it with an envelope, if any person who is in the between of the transmission of the letter, if he could access that particular letter by just removing that particular envelope, that fellow would be punishable. So that's how the communications were protected, and that notion of privacy has been emerged furthermore to protect our digital communications as well. Okay. Here, digital communications means whatever you speak with others using the telephone, mobile phone. Whereas in India as well, there is a one particular landmark case which said that the police officials cannot snoop into the communication of the people, which is rightly held in the landmark case of the PUCL versus Union of India. And later on, it is further developed. For in protecting the basic information of an individual. The basic information of an individual is considered as the personal data. The personal data is considered as one of the basic aspect of a person, which an individual, if he doesn't wish to share that information with others, then what law says is that that information should be protected. If the person is willing to share that information with others, law tries to provide in effective control over such a particular information. Suppose you are sharing any images to Facebook, you will be having effective control over that particular images. What is effective control here? You can decide who can view that particular photo and who cannot view. You can decide for what particular time that photo could be posted in the Facebook, or else you can entirely delete that particular Facebook, the image of the Facebook. So that's how the data protection aspect has been emerged, and we started recognizing protection of personal data as one of the basic and fundamental entities of right to privacy. So if you look at certain emerging aspects, we have a lot of global standards which govern the data protection. So I have mentioned the data protection as an aspect has been evolved, whereas for the first generation Data Protection Act is regulated was legislated first in Germany, German's SA Data Protection Act, whereas it was enacted to protect the personal data of the individuals. Basically, it happened when the German authorities tried to collect certain invasive information during the time of census. They started to ask the authorities started to ask certain information about certain basic personal details, which the people of Germans felt that if they disclose such information, they will be moving into the backwards, means the era which is similar to Nazi Germany. That's why a lot of issue has been emerged because of that, and then the case is went before the German Supreme Court, whereas the court has rightly held that even the basic aspect of personal data of an individual, personal information, it also comes under the ambit of his own privacy, and an individual has an aspect of self-determination about his own personal information. What is self-determination here? He should determine what he would do about that particular information. And later, international recognition has started to happen when the aspect of data protection is provided with certain OECD. OECD is a union conference of Arabian countries. They have provided certain guidelines, and then in 1990s, the European Union has started to draft about data protection law, and in 2020, it has got a rights-based approach by by conferring rights to the individuals. The famous landmark act enactment regulation on data protection was enacted by European Union. The name of the act is GDPR, that is General Data Protection Regulation. It is considered as a cornerstone regulation for the data protection. The most of the provisions of India's Data Protection Act are taken. I can't say inspired. There is a difference between being inspired and taken. In the notion of inspired, we can say we can see certain differences between the particular law and our law. But if I say taken, that means it is exactly similar. Most of the provisions we have taken the basic GDPR as a guideline to formulate our own data protection law. So if we look at the data protection framework, any kind of framework, we can see certain core principles, the core aspects. First thing is that if the data is being stored by anyone or processed by anyone, it should follow these principles. One is if a government or any of the entity of a state is collecting the data from the individuals, it should be lawful. fair and it should happen in a transparent manner. You see, that is this principle of the lawfulness, fairness, and a transparent manner has been taken from the landmark case of Justice K.S. Puttaswamy, which for the first time in India has recognized that right to privacy as a fundamental right, and that case has also enunciated certain principles of GDPR, and the other principle is purpose limitation. It means that whatever the data which is being collected, it should be for required purpose only. For suppose, dear friends, please try to answer the question. Let's make it a bit interactive. For suppose if you are going to a shop for purchasing medicines. If you are going to purchase certain medicines, and for purchasing medicine for the completion of the transaction, uh, the, the person who is selling the medicine, he asked about your financial details, about your monthly income. Is that particular information is relevant for the purpose of purchasing medicines? Can you answer? The shopkeeper has asked our monthly income.
No, sir, it's not relevant. It is my personal data and my personal matter. That's why it cannot be asked.
It cannot be asked. Your name? Can you introduce yourself?
My name is Aniket Sur. I am from LGD Law College, University of Calcutta, sir. I am currently pursuing in BLB 5 years. I am now studying in my second year.
Okay, nice. Just have a proper discussion about this and or suppose let us presume that you are filing ITR. Do you consider that providing the financial information is necessary?
Yes, sir. That in that case it would be necessary because it is a platform where I have to show my necessary income and expenses. It would be relevant over there, but not in a medical shop where I am purchasing any kind of medicine.
Okay, good. So the next aspect is that about storage limitation. It says that the data, whatever the entity is storing, it should be stored for a specified period until and unless the purpose is served, and it cannot be stored for indefinite period of time. For suppose if you have deleted your Facebook account, whatever data which is there with the Facebook, it should delete that account unless and until storing of the data is mandated by the law. Okay, so you see, in most of the we discuss about Facebook, the most of the apparent problem which will emerge with the Facebook is that there will be a lot of dead accounts than that of the active accounts. What are dead accounts here? Dead account means any kind of account which is opened by person. Either the user died, or he is not even using that particular Facebook account. So the problem is that what would happen to that particular personal data of that particular individual if he is not using that particular Facebook account? You see, we will be saved if the Data Protection Act is properly implemented in India, whereas it says that if in any kind of social networks site, if it remains inactive for a period which is more than 1 year, the draft data protection rules have mandated that the social networking site should delete that particular account. Before deleting that account, they need to communicate with the particular user with the reasonable communication methods, usually email. Okay, so and there are other certain core principles like that. There is data integrity. Whatever data which we shared, it should be remain in such manner only. No person in between should alter that particular image. Nowadays, we are facing a lot of big problem due to deepfake technology. Whereas a lot of the publicly accessible content of us is being used to create certain deepfake. Whereas why it is deepfake? Because they are using certain advanced artificial intelligence technologies to fake us. That's how it is known as deepfake. See that the issue of deepfake has been actually the discussion about deepfake has started with a particular video of I think yes.
Yes, sir.
Yeah. Do you like Rashmika Mandanna?
No, sir. That's not a matter of fact. Sir, because this topic is very, it is very interesting for myself, I think, because I have issued many of my journals and publications in this matter of AI and copyright fair trial policy. There has been the case of Facebook versus Union of India. You have known, I think.
Yes.
In which the Supreme Court said that the Facebook was using the data of the personal private people and using it for upgrading their meta policies. It was held as a violation of the right to privacy according to Justice K. Puttaswamy.
Yeah,
it was a very
actually as per yes, there are two cases. One about the WhatsApp privacy policy.
Exactly.
You need to look about a case where the Competition Commission of India has imposed 40 million rupees fine on Facebook, and the Facebook didn't get paid any fine because they felt that just by appealing they can escape.
Yes, sir. It's very funny that in India, where we have DPDP Act, which has the highest penalty amount of 250 million, more than 250 million.
Yes, it is. They haven't mentioned about any number. They said that it is 2% of their annual turnover. It is allowed. 2% is allowed.
No, sir. Whichever is higher, because in the schedule,
yes.
in the schedule, you will see that in the schedule it was mentioned the penalty amount to be specified. Minimum 250 million would be awarded, or 2% of total revenue
of the actual turnover.
Yes.
The major problem is that the rules haven't been implemented, and there is a data protection law for us, but it is still there on paper. But if you look at European GDPR, they are doing a splendid task, splendid job. They are imposing millions and millions of dollars of fine against these big entities, including Google, Instagram, TikTok, Facebook. They are under
yes, sir.
And even if you are interested, what I would suggest is that recently Uganda is my dear friends, Uganda is much more advanced than us, because Uganda for the first time has imposed fine. The Data Protection Authority of Uganda has imposed fine on Facebook. The reason being, they are not complying with the Uganda's data protection law. Their major defense of the Facebook is that if they comply with the international standards, then there is no need for them to comply Uganda's data protection law, for which the data protection officer said that how it could happen. If you are doing any business if you have any kind of users in Uganda, the data protection office has said that you need to comply with the laws of Uganda, and they have imposed fine. It is not a civil penalty. They are imposed fine and as per their jurisdiction of criminal jurisdiction of criminal in nature. My dear friends, with that, what I could say is that Uganda is much more advanced than us. Whereas in Uganda, there is no democracy in Uganda. It is actually they have a constitution, but it is governed by a monarchy. And now we are still figuring out when to implement our law. Yeah, Aniket, if I suggest you to read about this data protection with the data
In
protection
India, we are
authority.
still using the Act of 2000 IT Act 2000 for using and any kind of malpractices of our personal data. According to Section 66, I guess. 66, it was held for the any kind of breach of my privacy or my personal data and any further
But
illegal
if you look at the DPDP Act, whatever the provisions which are related to personal data, they stand repealed, even including your personal data rules of 2011 and even that 66A, they stand repealed, but it is yet to be implemented. Okay, let's move on to this issue. And yeah, it's good that we have knowledge. So the next thing is that apart from principles, as I mentioned, the data protection laws framework provides specify certain basic rights to the people. The right to be informed. How is the right to be informed is utilized here whenever any kind of entity is collecting the personal data of us, it need to provide for what purpose it is being collected and for what time it will be retained and how it will be used. So in our day-to-day lives, we are shown with enormous privacy notices. We don't read that privacy notices. We just click accept. Yeah, even I do that because if you're doing certain important and urgent tasks which needs to be done, but before doing that task, if somebody has arrived and they said that to do that particular task you need to read a privacy notice which takes around 30 minutes of time, then we feel it as a waste of time. But my dear friends, even if you give consent to that particular privacy notice, it doesn't itself mean that you are bound by that particular privacy notice. If such privacy notice is against to the Data Protection Act, that notice stands invalid. So we can say why I don't read notice, because the first thing is that it stands invalid, and second thing is that even if I accept or don't accept that particular privacy notice, our data is still remain with Google, and Google knows more than me than what I know about myself. It's the same for each and every individual. And the next thing is that we have a right to access and obtain one's personal information. So if any kind of entity, if it is trying to comply with that particular aspect, it should provide whatever personal information which is stored with them about us. Basically it is implemented in any kind of social networking site. Even if you in WhatsApp as well, you can request for your personal information and personal chats which are stored with the WhatsApp, and it will just show an enormous file which includes a lot of conversation, and it will also provide your deleted messages as well, the message which you are deleted for everyone. If you request that, try this thing, it will provide that deleted messages as well. So deleted messages are deleted only in fiction, but not in reality. And the next thing is that we have a right to erase, that means right to be forgotten. It is a basic fundamental right. It is considered as a basic fundamental right by our constitutional courts in number of judgments. Whereas a lot of individuals have approached the courts against these law reporting agencies like live law Indian Kanun, whereas they have just mentioned about certain the cases about certain individuals which are settled, means either the party is acquitted, and in one particular case they have the police officials have framed certain false charges against an individual, and he is repeatedly facing issue even after he got acquittal in that particular case. The issue is that whenever he is applying for the passport entities are searching about him on the web, and they are just seeing about his case, which is not updated properly, and they are feeling that a certain case is lodged against him. That's why they have rejected issuing of passport to him. So if this person has directly approached a high court, which is a constitutional court, and he sought for a right to be forgotten, which is recognized as a fundamental right in the case of justice case Puttaswamy. Whereas the court held that whenever the matter information is irrelevant with the law reporters like Indian Kanun live law, it stands to be deleted. And we have another right known as right to restrict processing. For suppose this is the issue which happened with the WhatsApp, whereas the WhatsApp has changed the privacy policy, and it has said that it has specified that it will process that information for the Facebook, and Facebook can use the information which is there in the WhatsApp for advertisement purposes. They won't say advertisement purposes, they say that for providing better, remember this word, personalized services. Not normal services, they are called as personalized services. What are personalized services? Here, they will show that in advertisements which are according to our own preference. They will show certain news feeds which are according to our own preference. That's why we are staying in a vicious loop, whereas we are just hooking on our mobile phone, and they're just continuously watching the content which is produced with them. It's not only happening with the teenagers. If you notice nowadays, even our parents as well, they are hooked with these phones. Parents use it to uh, um, the parents used to ask us to stop using the phone that much amount of time. But now what is happening is that we have to say this to our parents, because for them YouTube is providing a lot of content which they like, even not only YouTube, any kind of social networking site. So here, if you don't like to process that particular data, you will be provided with the right to restrict such kind of processing, and uh, and it is the latest right which has emerged, and sorry to say this, it is not included in our Data Protection Act. The right is right related to automated decision making. Right against the automated decision making means here the decision is not taken by the individuals, but they are taken by the automated systems. One of the basic example and one of the issue which is emerged about automatic decision making is with the CIBIL score. So the CIBIL score is mandatory for applying for any loans. Do you know who regulates the CIBIL score? My dear friends,
So there is organization. There is one single organization that regulates this whole CIBIL score from every bank or every financial institution.
Yes, there is single organization which is regulating, but the problem is that the organization is not governed or controlled by the government. It is a private entity.
Yes,
One single private entity is providing and maintaining the CIBIL score. When the person has filed an RTI, Right to Information Act, for this the Ministry of Finance about the CIBIL score, what the reply which they got is that Ministry of Finance doesn't have any data about the CIBIL score, because CIBIL score is completely regulated by a private entity, and he tried to ask that particular organization to provide about how they are evaluating or calculating the CIBIL score, for which they denied to answer about the process of evaluation. So you are you are under the constant pressure to maintain your CIBIL score, but you don't even know how to improve it. It is just like writing an exam, but you don't know the answers, and you don't even know the question paper as well. You are just in a big surprise. You are in the constant surprise. That's what is happening with CIBIL score. You see, internationally, not in India, because even the European courts also are trying to take an action to make the CIBIL score transparent, and the debate has been started about this as well. So these are all the basic rights or basic aspects which are governed under the data protection laws, and even in European GDPR as well, it has these particular aspects. So if you look at if you look at the international framework, we have GDPR, which means General Data Protection Regulation, which has an effective regulation framework. So GDPR law is comprehensive in nature. It is a single omnibus law which governs a lot of matters of data protection in Europe. If you look at the other side, we have in America, we don't have a single specific law regulation to protect the personal data of the persons in USA. They have certain different sectoral laws. For health personal data, there is a particular health law, that is HIPAA. For financial information, they have Graham Leach Bailey Act, GLBA. And recently, because in California as well, a lot of people, they have, in the state of California, they have enacted California Consumer Protection Act to protect the interests and rights of consumers. So this particular enactment has been drafted. It is a result of a referendum which happened in the states of USA, whereas the public of USA, they felt that their personal data has a value. More than 80% of the people felt that their personal data holds certain value, but more than 70% have felt that they are concerned with their own with the processing of personal data by these social networking sites. So with the particular research, uh, a direct pressure has been prompted for the regulation of California Consumer Protection Enactment, whereas it protects certain consumer rights. It's just like our own Consumer Protection Act as well. But here in California's uh, uh, California's Consumer Privacy Act, they have provided certain basic rights regarding the data protection. But you see, it is only one state-specific law, but it is concerned with the personal information which is taken by the entities. Whereas there is a relationship between the consumer and the service provider, but for others it is not applicable. So if you look at India, initially we used to have India's Information Technology Act. You see, it is so they felt that it is not enough to protect the personal data. That's why in the year 2008 they have introduced a provision in the name of 43A, which by saying that, for suppose if the entities are not using certain reasonable security practices for regulating sensitive personal data, then they will be penalized. And then we have got sensitive personal data protection rules 2011, which are only applicable for body corporates. So what is a body corporate here? It is any kind of entity which process the data for commercial purpose. Here, for this 2011 rules, it are not applicable to the governments because governments are not using data for commercial purposes. It is I said a joke as earlier. In reality, even the governments as well, they are using our data. And I am saying this thing. I am not saying particularly about our Indian government, but about the governments at large. If anyone asks who is the big accuser of our personal data, I would say government. I'm not saying any particular government. If I say Indian government, I will be in huge trouble. But I'm saying just the government because they're snoopers. So if you are willing to know about additional information, what I would suggest you is that first try to watch a movie which is in the name of Edward Snowden. Aniket, have you watched that movie?
No, sir, yet not.
You need to
I
watch.
would surely see.
You need to watch Snowden, where they have this is about the life of Edward Snowden, who is a NSA officer, NSA secret agent. Whereas he came to know that even his private life is being snooped by that National Security Agency of America, and he leaked the particular information. It's led to huge cry in America, whereas people have realized that America is a capitalistic country. They believe in the notion of laissez-faire, but they realize that the government, in the pretext of 9/11, they have started to snoop each and every individual's personal information. So, the same issue is happening with India as well. There is a lot of examples for that. One of the example is Aadhaar card only, and the next one is Arogya Setu, whereas the government has mandated the installation of Arogya Setu app to travel in public places. But certain people of Karnataka, they approached the High Court of Karnataka, which held that the installation of Arogya Setu app is voluntary, not compulsory. If we go in our discussion, the right to privacy is recognized for the first time in the Pudduswamy's judgment, whereas it tells that the right to privacy is considered as one of the basic and intrinsic part of right to life and personal liberty, and it comes under the ambit of Article 21. And it said that right to privacy is both a public and a private right, which means this right is equally applicable against state as you know. The nature of fundamental rights. Fundamental rights are only enforceable against state, except for few certain fundamental rights. Right against untouchability, right against exploitation, right against bonded labor. These are the rights which are applicable to the private individuals as well. But most of the fundamental rights are only applicable against state, including Article 21 as well. But the court said that the right to privacy is both which is applicable against state and against private actors as well, for which it has instructed in a stern voice to enact data protection enactment, and it happened in 2017, 16, I guess 2017. It took around 6 years for our government to enact the Data Protection Act in the name of Digital Personal Data Protection Act, which enacted in the year 2023. Okay, so if you look at Digital Personal Data Protection Act, it covers a kind of personal data only. So what is the ambit of Digital Personal Data Protection Act? For what kind of personal data it is covered, and it governs only the aspect of the personal data which is stored or processed under the digitalized form. Suppose if it means it's stored in any computer system, then only it is applicable. For suppose a particular person is using a pen and paper method to collect the information, the scope of digital personal data is not applicable to the collection of data. And next is that if you look at the application of the enactment as well, they will say another aspect which says It says that the Digital Data Protection Act is not applicable if you made the data publicly available. If you made that particular data publicly available, means if you share any image with Facebook, that image is made publicly available, right? If it is made publicly available, then then that particular image is not protected under DPDP Act. Yes, my dear friends, that kind of provision is not there in GDPR. I found that beautiful provision in DPDP Act only. I found such beautiful provision in DPDP Act only, but not anywhere else. And the DPDP Act has inspired with the rights-based approach of GDPR, whereas provided a lot of rights, right to access, right to erasure, which we have discussed. And they have also mentioned about substantial penalties as well, about 250 crores or 2% of turnover, which is very higher. And if you look at certain land cases which happened, so uh, so one of the landmark case which has about the data protection, you might know about this. It's about the Cambridge Analytica scandal, whereas it was first reported in the news article Guardian, whereas it says that the Cambridge Analytica, a British political consulting firm, had harvested a lot of millions of personal data from the Facebook users without their knowledge, and they have used that particular data to analyze and to build psychological profiles, and they have started targeted political advertising. So with this, it became a huge problem, this Cambridge Analytica scandal, whereas the European courts of justice has sanctioned Facebook for this. And my dear friends, it is just happening daily, regularly in India, whereas for political purposes and for non-political purposes as well, they are they are making certain targeted political advertisements. So Facebook, Meta, Google, they are under huge scrutiny with the European law, because European law is not even leading them. The reason being, the Facebook is not following established security practices. The passwords of the Facebooks in 2019, what happened was that they stored the password in the plain text without even encryption, which led to the loss of millions of passwords. And recently, as well, certain issue has emerged like this, whereas it said that 60% of the Indian social networking sites' personal data, which includes your username, passwords, it got leaked and it was made available in the dark web. In India as well, the Facebook is under huge scrutiny. So another important aspect, another emerging aspect which is relevant and important with the data protection laws is data protection impact assessment. It says that the entities, if they are crossing any kind of personal data, first what they need to do is that they are required to analyze the impact if any kind of potential breach happens. So if there is a huge potential breach of personal information of the individuals, then it is their necessity to safeguard the data by following robust practices. So so it is mandated under the privacy laws of across the globe, and in India as well we have that particular provision. And consent is considered as cornerstone for each and every data protection act. Processing of the personal data should happen except for certain cases. It should happen with the consent only, whereas if they are saying the consent, it should be free, specific, and informed. Means you should be freely give consent. You should give active consent. It doesn't mean that if you're using a website without even accepting, it doesn't itself mean that you accepted privacy policy. First, they need to provide the privacy policy. You need to accept that particular privacy policy. Then only it is deemed that you have consented for their processing. So, uh, so in India, if you look at certain issues with the data protection, the major problem with the Data Protection Act is that first thing is that it is not yet implemented. It should be implemented. They need to appoint data protection mechanisms. It is a it is a it is a long road. And the next problem is that they have in our India, if we critique about the Data Protection Act, the another aspect is that they have diluted the scope of the Data Protection Act by saying that only the digitalized digitalized personal data is protected, and they have diluted the scope by specifying that if the data is accessible for the public, then it is not protected. And the next criticism is that uh, in India, we don't have any proper recognition of special categories of data like sensitive personal data, racial data, genetic data, which requires certain robust protection. They have just blanketly mentioned about digital personal data, for which only one standard of protection is required. So the next thing is that they have prescribed in India, they have prescribed a lot of exemptions as well, which has uh, for which the DPDP Act became a toothless tiger. Certain exemptions has validated this CIBIL's activities. It mentioned that the private entities can, can process the personal data without the consent if it for knowing about the financial information. And the next thing is that employer employer can collect and process the personal data of employee without the consent. For employment purposes, it means that as per the Data Protection Act, you are under the constant scrutiny as per the terms of employment. So in India, they didn't even provide any of the aspect about automated decision making because it is becoming a huge challenge nowadays. Forget about loans. And next, a lot of people, especially anyone in this webinar who is attending is from Andhra Pradesh. Anyone is there from Andhra Pradesh? No one? Nice. So I'm from Andhra Pradesh, whereas our government is trying to use and deploy artificial intelligence for different purposes. Even for Darshan, even for Lord Balaji Tirumala Darshan as well, they are saying that they will use AI and AI will make the decisions about how fast a person could be given with the service of Darshan. If they are using this automatic decision making, the major problem is that automatic decisions are not made by the humans. That's the first issue. And second thing is that the decision making can be prejudicial and biased because whatever the decision it makes, it makes based upon the data which is available. If the data is not accurate, then the decision is not accurate. So it could cause a lot of problem as well. So in India, we don't have any provision about automatic decision making, and with artificial intelligence, the emergence of artificial intelligence, we are gonna face a lot of challenges, including the aspects of deepfake as well. So in India, for children, they have specified that effective The Facebook and Meta, they are not supposed to track the personal data of the children for commercial purposes. So they have provided certain paternalistic approach here, whereas parents of the particular children will have autonomy, and even the Facebook is also is under this particular task to change their user interface, whereas it to provide effective access to the parents on their children's account. But the major problem with this particular paternalistic approach is that a similar kind of approach is imposed for disabled persons as well. They can be both intellectually disabled and physically disabled persons. If a person is physically disabled as well, he is considered as disabled person under the DPDP Act, whereas the guardian will have person. So suppose if a person doesn't have the hand, he will be considered as disabled. But for the Data Protection Act, do you think that it requires guardian supervision about the processing of personal data? But our DPDP Act has drafted at such a level that it doesn't specify what kind of disability for which guardian's intervention is required. So this is about our Data Protection Act, whereas we have just started to frame the rules. Let's hope that we'll have a bright future regarding our own data. If you have any doubts, any points to share or any things to ponder upon, you can. If you have any doubts, you can ask. So for employment opportunities as well, data protection, the field of data protection and cyber law is considered as lucrative nowadays. There are a lot of universities which are offering LLM in cyber law and data protection, which you can do. But usually, I don't think that they're offering any kind of placements. But if you are willing to work in the industries, if you are a law student, if you are pursuing currently we're studying DLLB, or if you are willing to go for this data protection as a career, what I would suggest you is that there is a particular course which is being offered in NLIU Bhopal, which is Masters in Cyber Law and Information Security. It is not LLM. You cannot equate LLM with MCLS with LLM. With Masters in Cyber Law and Information Security, you will have industrial exposure regarding security aspects and the legal data protection aspects as well. And they are offering huge good placements in big 5 companies. Whereas the track record of this cyber law center in NLA Bhopal is that around 80% of the students will be placed from this particular course. So, it is not. You should take it with a caution. It's not LLM. You see, recently, Bar Council of India as well has provided certain guidelines, because Delhi University, the NLU Delhi has advertised about a course LLM professional, but in the heading they provided that they are offering course of LLM professional, but on the note in a tiny line they have written that LLM professional shouldn't be equated or considered as LLM general. So you see, even the topmost reputed law institute as well, they are deceiving people like this. Okay, so that's why I'm saying this. MCLS shouldn't be equated as LLM, but it offers a
online or offline?
Offline, man, not online. It is a 2-year course, whereas you need to write an entrance exam. The competition is comparatively less because and a lot of people don't know about this particular course. 2 years offline course. It is masters, regular degree. So in online as well, you can do a lot of courses. Current courses are there with Coursera. Or next, for cyber security, ICS2 is considered as what? A standard.
I've done courses on Coursera on Udemy. And
Yes.
it's hacking the AI.
What I would suggest is that, Mr. Aniket, what I would suggest each and every student is that ICS2 is offering a course. ISA2, which is a Information Security Council. ISA2 is offering a course on fundamentals of cyber security for free, which they will provide you need to complete that online course, and there will be having a prototype exam, and you will be shared certificate. So it is ISC2 certifications are industry relevant, but this fundamentals of cybersecurity course is for free because they just wanted to uh, improve the awareness of the people about as the fundamentals of basic fundamentals of cybersecurity. You can start with that.
Okay, sir. I found it. Thank you, sir, very much.
So thank you, everyone.
Thank you, sir, for
thank you,
this
Peter.
wonderful session. Thank you,
Yes.
everyone, for joining us for today's webinar. We appreciate your participation and hope you find the discussion informative and valuable. Stay tuned for future webinars and events. Thank you, everyone. Thank you so much, sir.
Thanks.
Sir, please share your PPT to the edge.
Can you say that again?
Sir, please share your PPT with the Nyashastra team.
Sure.
Your PPT is so informative.
I'll share this PPT.